Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Does a magisterial district court have jurisdiction to decide a case brought by the new owner of real estate to evict the prior owner? This is a topic that could be of interest to real estate owners, flippers, individuals involved in buying and selling real estate. A purchaser, in the particular case that I'm going to discuss, a purchaser purchased real property at a sheriff's sale after the owners failed to pay real estate taxes for many years. The now former owners petitioned the court to set aside the sheriff's sale. Their petition was denied, and that denial was upheld on appeal. But the former owners refused to leave their home. Now, the purchaser of the new home, of course, wants to get into the home to reside there himself or to rent the home for renters. But the former owners are still there. How do you get them out? The purchaser filed a complaint in the Magisterial District Judge's office, that's the MDJ, on a standard landlord-tenant complaint form seeking unpaid rent of $12,000 and possession of the property. The MDJ ruled in favor of the purchaser on a form denominated Notice of Judgment Transcript Residential Lease and granted the purchaser possession of the property as well as a judgment in the amount of $12,000 some dollars, representing the amount for rental arrears and for the filing fees. So the new owner, the purchaser, is very happy. He has an MDJ judgment for $12 some thousand dollars against the former owner and for possession, meaning the former owners have to get out. Well, that's not the end of the case. The former owners appealed to the Court of Common Pleas on the grounds that the MDJ lacked jurisdiction to decide the case because there was no lease and the parties were not in a landlord-tenant relationship. The Court of Common Pleas upheld the decision by the MDJ. So the new owner, the purchaser, is happy. He thinks he's going to get possession of the real estate he purchased. Not so fast. The former owner appealed to the Pennsylvania Superior Court, which agreed with the Court of Common Pleas. The former owner appealed. So, again, Superior Court agrees with the Court of Common Pleas. So the new owner, the purchaser, is feeling pretty happy. However, the former owner appealed to the Pennsylvania Supreme Court. The Pennsylvania Supreme Court reversed the Superior Court and the Court of Common Pleas. The case is Assoline v. Reynolds. It was decided November 20th of 2019. The Pennsylvania Supreme Court reviewed the jurisdictional bases for magisterial district judges. It also reviewed the Landlord-Tenant Act and determined, thus, it is plain to us that the jurisdictional grant in Title 42, which grants jurisdiction to MDJs over matters arising under the Act, confines MDJs to matters arising between landlords and tenants. It then held that the purchaser and the former owner were not in a landlord-tenant relationship, despite the forms that were used by the new owner in bringing the landlord-tenant claim, and the form that was used by the MDJ itself in issuing an order in favor of the purchaser. The Supreme Court said, thus the MDJ, despite the forms that were used, just does not have jurisdiction pursuant to the Landlord-Tenant Act. Thus, the Supreme Court reversed the Superior Court and sent the case back to the MDJ with instructions to dismiss the matter without prejudice to any rights that the purchaser may bring in an ejectment or other action appropriately framed in a Court of Common Pleas. So the new owner went all the way back to square one after litigating this case in the MDJ court, the Court of Common Pleas, the Superior Court, and then finally up to the Supreme Court, where he ultimately loses. And now he has to start from scratch by suing to eject the former owners in the Court of Common Pleas. An ejectment action is different than the eviction action that the new owner brought in the MDJ court. And the ejectment action is brought properly in a Court of Common Pleas, not an MDJ court. So had the new owner, the new property owner of this real estate, maybe had he obtained the right real estate lawyer from the beginning, he would have gotten this right and would have saved probably thousands of dollars in fees and costs that it took for him to lose at the highest court level in Pennsylvania. So, in short, that purchase should have, the purchaser, the new owner, should have filed an ejectment action in the Court of Common Pleas, but for whatever reason chose to bring this action as a landlord-tenant action in the MDJ court, even though it was not a landlord-tenant case. So, the answer to the question, does a magisterial district court have jurisdiction to decide a case brought by the new owner of real estate to evict the prior owner, is no. The MDJ does not have jurisdiction because the new and old owners are not in a landlord-tenant relationship. So, if you have any questions about landlord-tenant or real estate law, please do not hesitate to contact the real estate attorneys at Scaringi Law at 717-657-7770, or check out our website at scaringilaw.com. Well, that's all the time we have today for the Scaringi Law lunch break. I hope you learned a little bit about real estate law today. Thanks for listening and enjoy your lunch.